Hello everyone, this is Advocate Talusha. Again, you're watching me on LawPutra YouTube channel. Okay, so today's topic which we are going to learn about is Lok Adalat. Yes, what is Lok Adalat? Lok Adalat is also known as People's Court. Yes, Lok Adalat is a formal Indian judicial alternative dispute resolution forum that settles cases pending from the findings of a panchayat, an elected village council, and serves as the pre-litigation stage in a court of law. Lok Adalat is a traditional Indian method to relieve the overburdened court system by providing relatively quick arbitration. Yes. Decisions made through Lok Adalat have statutory status under the law, under the Legal Service Authorities Act 1987. Under this act, the verdict made by the Lok Adalat is deemed to be the same legal binding force as findings from the civil court, final for all the parties and not subject to appeal. Yes, if the parties do not recognize the findings of the Lok Adalat, they may initiate litigation by approaching the official court that possesses the appropriate jurisdiction. Yes, when the first Lok Adalat was held, does anyone knows about it or where it was? So I tell you, it was held in Gujarat. The first Lok Adalat was held in Gujarat in the year 1982. A Lok Adalat accepts cases pending in regular courts and which are under its jurisdiction. A Lok Adalat is presided over by the members of Lok Adalat. Members act as statutory conciliators. They can only persuade the parties, have to agree to be the judge through the forum. There is no court fee if a matter pending in a court of law is referred to a Lok Adalat and is subsequently settled. The court fee initially paid to the court is refunded to the parties. Yes. A Lok Adalat does not strictly follow procedural laws and the Indian Evidence Act while assessing the merits of the claim. The decision of Lok Adalat is binding, can be executed by a court of law. All proceedings in a Lok Adalat are recorded and maintained for future reference. It is also known as a court of record. Yes, a Lok Adalat usually resolves disputes, civil cases related to financial matters, partition suits, damages, matrimonial law, family disputes, and compoundable criminal cases. Section 22B of the Legal Service Authorities Act provides for the establishment of a permanent Lok Adalat for exercising jurisdiction in respect to one or more public utility services. Section 22A of the Legal Service Authorities Act 1987 states as to what constitutes a public utility service for a permanent Lok Adalat. Yes, now we'll come on a topic of a permanent Lok Adalat. What is permanent Lok Adalat? A permanent Lok Adalat is a civil court that has been set up under the Legal Services Authorities Act. It is composed of a chairperson who is serving or retired district or section judge or a judicial officer higher in the rank, and two other members who perform general judicial duties. The court is not bound by the Civil Procedure Code 1908 and the Indian Evidence Act 1872. Having the power to devise its own procedures, a permanent Lok Adalat may summon a person or document among other evidence. Yes, the pecuniary jurisdiction of a permanent Lok Adalat is 1 crore rupees. Yes. In case that have no direct monetary connection, the permanent Lok Adalat can pass any order within the orbit of any statutory or constitutional mandate. Now, the permanent Lok Adalat is like the system, permanent Lok Adalat system has been set up nationwide, such as I'll tell you, Delhi, Kerala, Rajasthan, Andhra Pradesh, Uttar Pradesh, Punjab, Kanpur, Allahabad, Lucknow, Bagpat, Meerut, Ghaziabad, and many others. The then Chief Justice of India, Adarsh Sen Anand, while addressing the annual meet of the State Legal Services Authorities in 1999, made some observations as to the legal power of the permanent Lok Adalat. What was it? There will be no harm in the league. There will be no harm if the Legal Service Authorities Act is amended to provide that in case, in a matter before it, the judges of the Lok Adalat are convinced that one of the parties is unreasonably opposing a reasonable settlement and has no valid defense whatsoever against the claim of the opposite party. They may pass an award. Based on the materials before them without the consent of the parties standing in the way of settlement. Yes. Around in the year 2002, the Union Parliament amended the Legal Service Authorities Act 1987 to provide for the setting up of the permanent Lok Adalat. Article 323A and 323B of the Indian Constitution provides for tribunals. Article 323A deals with administrative tribunals. Article 323B deals with tribunals for other matters. As per Section 22(3) of Legal Service Authorities Act, all proceedings before a permanent Lok Adalat, all proceedings before a permanent Lok Adalat shall be deemed to be a judicial proceedings, shall deemed to be a judicial proceedings within the meaning of Section 193, 290 and 228 of the IPC, Indian Penal Code, and every permanent Lok Adalat shall be deemed to be a civil court for the purpose of Section 195. Thank you.